It's October 2030. 22 American law schools are shutting down. They aren't merging, they aren't renovating, they are finishing out their remaining students and closing their doors forever. Just 4 years earlier, in 2025 and 2026, those same institutions were enjoying historic application numbers. Politics were chaotic, AI was disrupting tech careers, and a law degree felt like a safe harbor. First-year class sizes hit decade highs. Institutions reacted to this surge by taking out massive loans to expand. They broke ground on pristine new facilities, operating on the assumption that this applicant boom was a permanent new reality. To finance this growth, universities typically issue what are called revenue bonds. These are complex loans that come with a strict legal requirement. An institution's tuition revenue must stay above a specific minimum threshold every single year, or the school goes into default. Unlike a nimble small business that can quickly cut costs when demand drops, a mid-tier private law school is a massive, slow-moving machine. They have tenured faculty to pay, huge buildings to maintain, and they rely entirely on tuition dollars to keep the lights on. Those record-breaking application numbers masked a deeply fragile financial system. These schools had built enormous fixed costs around a temporary spike, leaving them vulnerable when multiple crises converged at once. For years, the system relied on a federal program called Grad. If you got into any accredited law school, the government would loan you the full cost of attendance, covering your tuition, your living expenses, and absolutely everything. Because students could borrow unlimited amounts, schools could charge exorbitant prices without worrying if their graduates actually landed high-paying jobs. This chart breaks down the new legislation. In 2026, federal borrowing was capped at $150,000 total. But 3 years at a private law school often costs $270,000, carving out a $120,000 gap. To fill it, students turn to private lenders. But if you attend a mid-tier school where graduates make $55,000, banks refuse to take the risk. Removing government subsidy exposed the disconnect between mid-tier tuition prices and real-world salaries. Students simply could not afford to attend, and the schools had no backup plan. Historically, the LSAT functioned as a financial control for law school budgets. It served as the universal yardstick schools used to calculate tuition discounts. High scores got full rides, lower scores paid full price. Then the American Bar Association allowed schools to go test optional, admitting students without any standardized score at all. Without that common measurement, schools couldn't accurately price their product. To lock down applicants, they offered massive scholarships, sparking blind bidding wars. These test-optional policies turned a controlled financial system into a race to the bottom. Schools were giving away too much money, starving their own operating budgets from the inside. While revenue plummeted, the applicant pool itself was shrinking. A severe dip in birth rates during the 2008 recession created a demographic cliff, resulting in a 15% drop in college graduates hitting the market by 2028. Simultaneously, the legal job market contracted. AI tools advanced to the point where they could automate routine tasks like document review. Law firms quickly realized they could hire one junior associate using AI to do the work that used to require 3. Students rushed into law school to escape the disruption of AI, only to graduate into a legal market where AI had already eliminated the exact entry-level jobs they went to school to get. Fewer humans applying to school, combined with a fraction of the entry-level jobs waiting for them, eroded the fundamental value of a mid-tier law degree. This is where the math becomes lethal. Plummeting revenue from scholarship bidding wars, combined with a shrinking student body, directly collided with the strict minimum tuition requirements of those new building loans. This chart visualizes the trap. To avoid defaulting, schools must fill seats at any cost. They admit weaker students and hand out larger scholarships just to hit enrollment. But desperation has a delayed cost. 3 years later, those students fail the bar. Passage rates plummet, employment outcomes tank, scaring away future applicants, forcing the school to offer even bigger scholarships. Dozens of law schools are failing not because of a single scandal or misstep, but through sheer mathematical inevitability. When a rigid, debt-burdened system suffers multiple structural fractures at the same time, collapse is the only outcome. The damage, however, is not evenly distributed. Elite institutions with massive endowments simply shrink their class sizes and weather the storm untouched, but the middle of the market splinters. The national standard of American Bar Association accreditation begins to crack, with states like Texas and Florida moving to establish their own isolated licensing systems. The law degree persists, but its universal portability has evaporated. The market has permanently fractured into distinct tiers of winners and losers. If you are applying to law school today, you must calculate your actual financial burden under the strict new federal borrowing caps. Do not rely on the optimistic math printed in a brochure. Look up a school's 509 data. This is a publicly available American Bar Association report that gives you the raw, unfiltered numbers on exact employment rates and starting salaries for recent graduates. Evaluate an institution's financial stability as closely as you evaluate its academic rank. Taking on debt for a discounted degree from a struggling institution is a massive risk. A full-ride scholarship to a law school that shuts down before you graduate is worthless.